course.
Can I turn to ground 2? There are two main issues on ground 2. First, are these proceedings a civil and commercial matter for the purposes of Article 1.1 of the Brussels Recast Regulation? That regulation is to be found, just for your Lordship's reference, at PA10, tab 89. And your Lordships will be very familiar, I'm sure, with Article 1, which appears PA10 stroke 89, page 6. This regulation shall apply in civil and commercial matters, whatever the nature of the court or tribunal. It shall not extend in particular to revenue, customs or administrative matters, or to the liability of the state for acts and omissions in the exercise of state authority. And there's been some jurisprudence, as I'll remind the Lordship, on the origins and purposes of that second sentence. The judge below answered that first question, is it a civil and commercial matter, in the affirmative. And he so decided in relation to all the respondents, not just the Solo, etc. respondents, but the ED&F respondents as well.
Yeah.
But we say he was correct to do so, or at the very least he was entitled.
Well, it's counterintuitive. I know nothing to do with the Brussels regulation in any of its emanations should depend upon intuition in any form. But if you're right about ground 1, then it's very difficult to see how you get to the point where this isn't a civil and commercial matter with respect. I mean, the judge's analysis is might be said to be inconsistent in one sense, but if you're right about ground 1, then his analysis is correct.
I respectfully agree. The reason I'm going to take your Lordships through it, not a
I'm not suggesting you shouldn't. I'm simply indicating.
But your Lordship's right in my submission. We say in any event there is a Court of Justice case law which strongly supports the argument in any event, just looking at this from a European perspective. This is a civil and commercial matter, even though it is a claim that has its background, if I can put it that way, in tax matters. So we say the judge was right on that point. The respondents have cross-appealed. They say he was wrong. But there's a second issue. If the judge was correct that this is a civil and commercial matter, is Dicey Rule 3.1 nevertheless applicable to these proceedings? And the judge below said yes. In the affirmative, he held that the claims failed under the Brussels regulation as under domestic law because Rule 3.1 still applies. And he so concluded because he said that the regulation is concerned with jurisdiction. It doesn't prevent a state from applying its own rules of public policy, such as Dicey Rule 3.1. And I'll show you, Lordships, that conclusion departed from the view obiter dicta of this court in the Franzen case in 1999, and I'll come to that. There is, I think, no dispute. There's certainly no indication to the contrary of my friend's skeleton arguments. I think there's no dispute between the parties that notwithstanding Brexit, the Brussels regulation in its full glory continues to apply to proceedings such as this, commenced before...
Because the proceedings were already on pending.
Yes, indeed.
And therefore, by virtue of Article 67 of the...
67(1)(a).
67 of the withdrawal agreement.
Yes.
And then there's some section that's inserted by the 2020 Act in the 2020.
Precisely so. Can I show your Lordships the material very, very briefly?
Yeah.
Just so your Lordships have it. If your Lordships go to the principal authorities, PA 10, tab 92, your Lordships will find the relevant provisions of the withdrawal agreement, PA 10/92. And if your Lordships in that tab 92, have page 2, your Lordships will see at the bottom of the page Article 4. And Article 4.1 says the provisions of this agreement and the provisions of union law made applicable by this agreement shall produce in respect of and in the United Kingdom the same legal effects as those which they produce within the Union and its member states. Accordingly, legal or natural persons are in particular able to rely directly on the provisions contained in this agreement, which meet the conditions for direct effect. 2, the UK has an obligation. It shall ensure compliance with paragraph 1, including as regards the required powers of its judicial and administrative authorities to disapply inconsistent or incompatible domestic provisions through domestic primary legislation. 3, the provisions of this agreement referring to union law or to concepts or provisions of thereof shall be interpreted and applied in accordance with the methods and general principles of union law. And 4, the provisions of this agreement referring to union law or to concepts or provisions thereof shall in their interpretation and application be interpreted in conformity with the relevant case law of the Court of Justice of the EU handed down before the end of the transition period. That's the end of December 2020. So we're looking at it, as it were, through European eyes, and the relevant provisions of law include, see page 4 of this document, Article 67, as your Lordship indicated, which covers jurisdiction, recognition and enforcement of judicial decisions and related cooperation. 1, in the UK, as well as in the member states in situations involving the UK, in respect of legal proceedings instituted before the end of the transition period, and in respect of proceedings or actions related to such legal proceedings, the following acts or provisions shall apply. And the first of them is the Recast Regulation.
Yeah.
So that's the European perspective. This is implemented into domestic law by the preceding tab 91, PA 10/91, which is section 7A of the EU Withdrawal Act. And your Lordship see from page 1, section 7A, 1, subsection 2 applies to all such rights, powers, liabilities, obligations and restrictions from time to time created or arising by or under the withdrawal agreement, and all such remedies and procedures as in accordance with the withdrawal agreement are without further enactment to be given legal effect or used in the UK. And 2, they're all to be recognised and available in domestic law and enforced accordingly. And every enactment, including an enactment contained in this Act, is to be read and has effect subject to subsection 2. So there's more provisions, but that's good enough in my submission to make clear what the position is in relation to these proceedings. Now, the first question then is whether the judge was correct, or at least entitled to decide, that SCAT's claims are civil and commercial matters applying the jurisprudence of the Court of Justice. There's no dispute between the parties that the Court of Justice has regularly stated that the promotion of the objectives of the recast regulation requires a, quote, autonomous interpretation of these concepts, civil and commercial. If your Lordships need an authority, it's, and I don't invite the court to turn it up, it's PA 9, tab 82. It's the BUAK, B-U-A-K judgment, paragraphs 46 to 47. The second sentence of Article 1.1, the one that refers to revenue and public law, was explained by the Court of Justice in the Tiard case, which can be found, invite the court please to look at PA 8, Principal Authorities 8, tab 7070. And the court dealt with this matter at paragraph 38, which is on page 19 of the judgment of the Court of Justice. Paragraph 38 on page 19, your lordships see, in that regard it should be recalled that the second sentence of the first paragraph of Article 1 of the Convention, which of course is the same terms as what is now the Recast Regulation, was added by the Convention of 1978 on the accession of Denmark, Ireland and the United Kingdom to the Brussels Convention in order to clarify, by means of examples, which matters do not fall within the scope of the Brussels Convention. That sentence seeks only to draw attention to the fact that customs matters are not covered by the concept of civil and commercial matters and the other matters that they are mentioned. That clarification did not, however, have the effect of either limiting or modifying the scope of the latter concept. That's the meaning of civil and commercial. That's what they say. It's also well established, my lords, that proceedings do not cease to be civil and commercial matters merely because the claimant, or indeed the defendant, is a public authority. The test is whether the public authority is acting in the exercise of its public powers. There are many, many statements to that effect, but one will suffice. If we go to the Buac case, which I mentioned a few moments ago, PA 9 at tab number 82, I'd mentioned a few moments ago paragraphs 46 and 47. Well, paragraph 46, that's the one where they say the concept of civil and commercial. This is on page 26, I'm sorry, page 26. Paragraph 46 was what I'd mentioned, that the concept of a civil and commercial matter is an autonomous concept. Can I also draw attention to paragraph 49? This is the principle. As the court has repeatedly held, although certain actions between a public authority and a person governed by private law may come within the scope of the regulation, it is otherwise where the public authority is acting in the exercise of its public powers. See the Sunico case to which I'm coming. The exercise of public powers by one of the parties to the case, because it exercises powers falling outside the scope of ordinary legal rules applicable to relationships between private individuals, excludes such a case from civil and commercial matters within the meaning of Article 1.1. Now, the case there identified as central to the principle, and I also invite your lordships to note that this judgment of the court was a judgment of the second chamber, but it included, see page 1, as presiding judge, Judge Lenartz, who of course was the president of the court. So the Sunico case is cited at paragraph 49, and Sunico can be found in PA 9, same bundle, PA 9 at tab 77, PA 9/77. This is a judgment in 2013, and it demonstrates, my lords, in our submission, how the Luxembourg court applies the concept of civil and commercial matters in a context very closely analogous, we say, to the present case. The head note explains on page 1 the context. The revenue, as the Revenue and Customs Commissioners of this country, brought proceedings in the High Court against a number of natural and legal persons who were domiciled in Denmark, including the defendants. And the allegation was that they had been involved in a VAT carousel-type fraud which had led to the evasion of output VAT to the detriment of the UK Treasury. the defendants, who were allegedly the real beneficiaries of the sums obtained by the tax evasion, were not themselves subject to VAT in the UK, and the person subject to UK VAT who was involved in that fraud was not a party to the proceedings. Since the defendants had not incurred liability under UK VAT legislation, the commissioners, HMRC, based their action on tortious conspiracy to defraud. There were parallel Danish proceedings brought by the HMRC against the defendants, and in those parallel proceedings, the Danish court made an attachment order in respect of assets belonging to the defendants situated in Denmark in order to secure payment of the claim for damages. The revenue, acting on the basis of Danish legislation, then asked the Danish court to confirm the attachment orders, and they claimed payment from the defendants of a sum corresponding to the amount of the VAT which had been evaded by those liable to tax. The defendants' argument, they submitted that since the claim was a tax matter, it was expressly excluded from the ambit of the regulation by Article 1.1. They were looking at the original regulation, not the recast regulation, but there's no material difference. The Danish court, missing out 3 lines, the Danish court then referred to the Court of Justice for a preliminary ruling, the question as to whether the scope of the regulation extended to cover a case in which the authorities of a member state brought a claim for damages against undertakings and natural persons resident in another member state, that's Denmark, on the basis of an allegation made pursuant to the national law of the United Kingdom of a tortious conspiracy to defraud, consisting of an involvement in the withholding of VAT due to the first member state, that's the United Kingdom. So that's the context, and the argument was this essentially is a revenue matter, because it's all about the evasion of VAT, and you're claiming damages that are in the same quantity as the VAT which was evaded. If we go to the judgment, can I invite the court to pick it up at paragraph 29, which is on page 18. This is the Court of Justice judgment, paragraph 29. The court says, by its question, page 18, on page 18. That's not page 18, I don't think. That's page 18, thank you. Paragraph 29. By its question, the referring court seeks to ascertain, in essence, whether the concept of civil and commercial matters within the meaning of Article 1.1 is to be interpreted as meaning that it includes an action whereby a public authority of one member state claims from natural and legal persons resident in another member state damages in respect of a loss caused by a conspiracy to commit VAT fraud in the first member state. 30. Sunico, which maintains that the proceedings before the referring court should be continued, claims that a judgment delivered by the United Kingdom courts in the action for damages brought against it is not capable of producing binding effects in Denmark. Such a judgment would not be enforceable in Denmark under the regulation, insofar as the Commissioner's claim for damages is based on the fact that a third party subject to VAT in the UK did not pay that tax, and so that claim is governed by UK VAT law. Accordingly, in their submission, such an action does not come within the scope of the regulation, since actions in revenue matters are expressly excluded. And then there's the argument for the Commissioners. Then I think I can go to 33 on the next page, page 19. It must be stated the scope of the regulation, like the Convention, is limited to civil and commercial matters. It follows from settled case law that the scope is defined essentially by the elements which characterise the nature of the legal relationships between the parties to the dispute or the subject matter thereof. And they refer to the Sakia case, to which I'm coming. 34. The court has thus held that although certain actions before a public authority in a person governed by private law may come within the scope of the regulation, it is otherwise where the public authority is acting in the exercise of its public powers. See again, Sakia. 35. In order to determine whether that is the case in a dispute such as that in the main proceedings, it is necessary to examine the basis of and the detailed rules applicable to the action brought by the commissioners in the UK before the High Court. 36. In that regard, it should be noted that the factual basis of the claim before that court, that's the British court, is the alleged fraudulent conduct of Sunico and the other non-residents sued in that court, who are alleged to have been involved on the territory of the UK in a chain of transactions involving the sale of goods with the aim of setting up a VAT carousel type tax evasion mechanism, and then they set out the details, enabled outward tax payable by a taxable person to be evaded, and thus to have been the real beneficiaries of the sums obtained by means of that tax evasion. 37. So far as the legal basis of the Commissioner's claim is concerned, their action against Sunico is based not on UK VAT law, but on Sunico's alleged involvement in a conspiracy to defraud, which comes under the law of tort of that member state. 38. Likewise, it is clear from the decision for reference that Sunico and the other non-residents sued in the High Court are not subject to VAT in the UK and are therefore not liable to pay VAT under the laws of the United Kingdom. As the Commission and the UK have observed, in the context of that legal relationship, the Commissioners do not exercise any exceptional powers by comparison with the rules applicable to relationship between persons governed by private law. In particular, as the Advocate General has stated, paragraph 44 of her opinion, page 402, which I will come to on page 12 of the electronic transcript, the Commissioners cannot, as they are generally able to do in the exercise of their powers as a public authority, themselves issue the enforceable document that would enable them to recover their debt. But in order to do so in a context such as that of the main proceedings, they must proceed through the normal legal channels. It follows that the legal relationship between the Commissioners and Sunico is not a legal relationship based on public law, in this instance tax law, involving the exercise of powers of a public authority. Admittedly, it is apparent from the order for reference that the amount of the damages claimed by the Commissioners corresponds, over the page, page 20, to the amount of output tax payable by a taxable person. However, the fact that the extent of Sunico's tortious liability towards the Commissioners and the amount of the tax claim against a taxable person are the same cannot be regarded as proof that the Commissioners' action before the High Court involves the exercise by them of public authority vis-à-vis Sunico, since it's common ground that the legal relationship by the Commissioners and Sunico is not governed by United Kingdom VAT law, but by the law of tort of that member state. Then they turn at 42 to 43 to a distinct question, which is the use of powers to obtain information. I'm coming to that, but can I leave that for a moment and just deal with the main point that is made by the Court of Justice. I did say I'd go back to the Advocate General. There's a reference to what she had said at paragraph 44. Yes, at 44, which is on page 12. The Advocate General said the Commission and the UK further submit that in the present legal dispute, the Commissioner is not exercising powers going beyond those existing under the rules applicable to relations between private individuals, and there's some authority. the commissioners and the defendants are acting as two private persons, the same procedural rules apply as for anyone else, and the proceedings are governed by civil procedure. In particular, contrary to customary practice in the exercise of public powers, and especially in tax law, the commissioners cannot itself enforce and execute the claim. They must pursue it through the general courts of law. And it may also be helpful just to look at paragraph 49 of that opinion, which is on the next page, page 13, where the Advocate General says a connection with public powers might arise from the fact that behind the damages arising, there ultimately lies a tax claim, and hence a sovereign relationship that is crucial to the amount of the claim being enforced. The claim for damages corresponds in terms of its amount to the VAT lost. However, in assessing the question whether it is a civil and commercial matter, only the actual subject matter of the dispute must be taken into account and not its background. Now, we say that is very important for the issues in this case, because applying the reasoning of the Court of Justice and indeed the Advocate General, we say the following points can be made. First, in the present case, as in Sunico, see paragraph 37, the basis of our claim is not Danish tax law, although of course Danish tax law is in the background. The basis of our claim is the defendant's involvement in the Solo cases in a conspiracy to defraud, which comes under the law of tort. And in the case of the ED and F man respondents, where there's no allegation of fraud, the claim is also not a claim for tax. It's for the recovery of sums paid over by SCAT by reason of misrepresentation. Basis of the claim is not Danish tax law. That's the first point. The second point is that, as in Sunico, paragraph 38, those being sued are not persons who are liable to pay tax. There was no tax. There was no liability to pay tax. There were no relevant shares. There was no tax withheld. The third point, by reference to Sunico, paragraph 39, is like the claim in Sunico, we are proceeding through, quote, normal legal channels, paragraph 39. We're not seeking to enforce a tax debt by the use of special powers. As your lordships appreciate, what the court is there referring to are circumstances where the tax authority issues a decision which is binding and effective unless and until overturned by the relevant court. We have to prove our case in the High Court, our claim of fraud or misrepresentation. Fourthly, we say it therefore follows in this case, as it did in Sunico, paragraph 40, and I quote, the legal relationship between SCAT and the defendants is not a legal relationship based on public law, in this instance tax law. It's a relationship for the purposes of this claim, and I remind your lordships of what the Advocate General said at paragraph 49, it's this claim that matters. The relationship is a relationship of normal private law for the purposes of this claim. And fifth, I would submit that our case, the present case, is even stronger than Sunico, because in Sunico there was a taxable person with a duty to pay output tax, see paragraph 36. In this case, there is no taxable person. Certainly in the Solo cases, and it appears also to be the case in relation to all or some of the ED&F man cases.
But so in other words, there was an outstanding tax claim there.
In Sunico.
Not one against the particular defendant.
Precisely. So this is a stronger case in that sense, and particularly as the position...
Sorry, hang on.
I'm sorry.
And the distinction then is that it couldn't be said in Sunico and a fortiori, you would say, it can't be said in this case, that what was happening was an indirect enforcement of the outstanding tax claim.
Precisely so, particularly when the Court of Justice said that it expressly said that it did not affect the conclusion that this was a civil and commercial matter, that the amount of money which was being claimed precisely correlated to the tax that had been lost. That's the strength of the Sunico case.
It doesn't appear, is this right, that before the Danish court, there was resort to the equivalent of Dicey Rule 3.
No.
Obviously, it wouldn't be relevant in the proceedings in the UK because they were the UK commissioners applying UK law.
If that was an issue in the Danish court, if there was some equivalent Danish provision of national law, it's not referred to by the Court of Justice.
It doesn't emerge, does it? No.
So we rely on Sunico. We say that that's the closest analogy. There are many, many cases decided by the Court of Justice under Article 1 of the regulation. But we say that is the governing principles. And it was essentially because of the Sunico case that the judge below concluded at paragraphs 149 and 164 that this is a civil and commercial matter, leaving aside the use of powers to obtain information, to which I need to come and am coming. But subject to that, Sunico, we say, is not merely on all fours, but it's a much stronger case than the present case in the sense of the interconnection between the claim that was being made by the revenue and the tax system. But notwithstanding that, the court says, no, you must focus on the nature of the claim before the court. And it's a claim in private law for a recovery of damages for a fraud. Admittedly, a fraud committed on the revenue, but that doesn't make a difference. And that's what we rely upon. It's the first thing we rely upon. I said I would return, and I am now returning to what was said in Sunico about the use of evidence obtained by the use of public powers. And if your lordships go back to tab 77, PA9 tab 77, and your lordships return to where I broke off on page 20, the Court of Justice addresses at paragraph 42 the further point. They say at 42 last as to whether the request for information which the commissioners addressed to the Danish authorities on the basis of a regulation before bringing proceedings before the High Court of Justice affects the nature of the legal relationship between the commissioners and Sunico. It should be observed that it is not apparent from the documents in the file before the court that in the proceedings pending before the High Court, the commissioners used evidence obtained in the exercise of their powers as a public authority. However, as the Advocate General has stated at point 45 of her opinion, it's for the referring court to ascertain whether that was the case, and if appropriate, whether the commissioners were in the same position as a person governed by private law in their action against Sunico and the other non-residents sued in the High Court of Justice. And if we go back to the Advocate General, just to be clear what she had said. Paragraph 45 is on page 12, my lords. Paragraph 45 of the Advocate General, page 12, she says, however, the fact that before applying for the attachment order in Denmark, the Commissioners requested information on the defendants from the Danish authorities might give rise to difficulties. The request for information is an instrument that is not available to a private applicant. It's not, however, clear from the information before the court whether or to what extent the request for information was also relevant to the proceedings before the High Court. In any case, if it were admissible in national procedural law for the Commissioners to use that information and evidence obtained in the exercise of its powers in the proceedings before the High Court, the Commissioners would not be acting against the defendants as a private person. Whether and to what extent that is the case must be determined by the referring court. Now, the judge below addressed this question, and his lordship's conclusion, we say accurately, was that this part of Sonico, that is the use of powers to obtain information, the use of that information has been clarified in more recent cases. And there are two more recent cases. One is Buak, to which I've already referred, and the other is Movic. And the judge below, it's at paragraphs 166 to 167 and 174, concluded, we say correctly concluded, that the touchstone is whether some special role or status is given to the evidence adduced by the public body. That's the question. Is it using material which is given a special status or a special role? That's the test. And his lordship so concluded because of Movic and Buak. Can I take your lordships to those judgments? The first of them, Movic, is in PA9 at tab number 84, PA9/84. And this is the Court of Justice in 2020, July 2020. And the context here is proceedings brought by the state against companies who were selling tickets for events at a premium, a topic that's provoked much litigation here and elsewhere. And the Belgian state was seeking a declaration that this was unlawful and an order to prevent the company from continuing to act in this way. And the Advocate General, taking his opinion first in Movic, referred to Sonico at paragraph 51, which is on page 18, PA9/84/18. And at 51, the Advocate General said this. He said the court affirmed in Sonico that it was not apparent from the documents in the file before the court that in the main proceedings, the public authority had used evidence obtained in the exercise of its powers as a public authority. The court held it was for the referring court to ascertain the position, etc., etc. At 53, I also understand Sonico, that judgment, as holding that in order to exclude proceedings from the scope of civil and commercial matters, it is not sufficient to identify national provisions which in abstracto authorise a public authority to gather evidence through the use of its public powers and to use such evidence in legal proceedings. Equally, it is not sufficient to find that the evidence has in fact been used in the proceedings. In order to exclude the proceedings from the scope of that expression, it must also be determined in concreto whether by virtue of having used that evidence, the public authority is not in the same position as a person governed by private law in analogous proceedings. And then on the next page, page 19, the Advocate General emphasises at 56, AG 56, the fact that evidence gathered through the exercise of public powers is used in proceedings does not automatically affect the legal relationship between the parties to those proceedings or the subject matter of the proceedings. 57, person governed by private law can also use evidence which has been gathered by a public authority through the exercise of its public powers. And he gives the example of road traffic accidents, documents produced by the police. You can ask the National Court for production of the documents, and in competition law proceedings likewise. 58, the fact that special probative force may attach to a document which has been drawn up by a public authority does not make this any less clear. The rules under which such force is given to certain types of evidence are equally applicable in proceedings between private persons. And then he says any other approach at 59 would undermine the practical effectiveness of consumer protection. And at 60, all this being so, a public authority may have powers enabling it to use evidence which is not available to persons governed by private law. For example, national law may provide for evidence gathered by an authority to be confidential and for the authority to decide whether or not it's disclosed. Different arrangements under national procedural law may apply where the same evidence is challenged by the other party, depending on whether it's been produced by a public authority or a person governed by private law. In my opinion, he says at 61, these situations correspond to the one envisaged in Sunico, in which the fact that the public authority has used certain evidence means that it's not in the same position as a person governed by private law in analogous proceedings. And he says there's nothing in the case before him to indicate that that is so. And that opinion was endorsed by the court. The court at paragraph 55, which is on page 33, paragraph 55, this is the court speaking. They say the defendants in the main proceedings emphasise the fact that the Belgian authorities use their own reports and findings as evidence, so that the crucial documents consist of a series of reports and findings by state inspectors. As noted, 56, as noted by the Advocate General in 59 of his opinion, to hold that proceedings brought by a public authority are outside the scope of the regulation merely because of the use by that authority of evidence gathered by virtue of its public powers would undermine the practical effectiveness of implementation of consumer protection. And then at 57, only where, due to the use to which a public authority has put certain pieces of evidence, it is not specifically in the same position as a person governed by private law in the context of a similar action, would it be appropriate to make a finding that such an authority has, in the particular case, exercised public powers. Merely collecting and compiling complaints or evidence cannot amount to the exercise of those powers. And at 59, Belgian authorities have not made any use of evidence. And 60, it follows that an action where the opposing parties are the authorities of a member state and businesses established in another state in which those authorities seek findings of infringements do fall within the scope of the concept of civil and commercial matters. So that's the test. Have you used evidence in such a way that the evidence has some special status in the proceedings which you are bringing? The focus is on the use of evidence and whether it thereby puts the public authority in a different position because of the status of that evidence. The other case is Buac, which your lordships have already seen at PA 9 tab 82. This was an earlier judgment. I'm sorry, I did not take them in chronological order. I should have done. Buac was a year earlier, February 2019, and I've already referred to the presiding judge being Judge Lennartz. This was, as the head note probably easier to read the head note at H3 on page 1. The questions referred arose in the Court of Proceedings brought by the Austrian Construction Workers Fund, that's BUAC, for the issue of a certificate referred to for the purposes of enforcing a final judgment against a company, BUAC, against a company. BUAC was a body governed by public law that was responsible for collecting the funds required to satisfy claims under an Austrian law regulating paid leave and severance pay of workers in the construction sector. And the company hadn't paid. And the question, one of the questions, was whether this was a civil and commercial matter. And the Court of Justice, starting at paragraph 57, which is on page 27, paragraph 57 sets out the context, whether or not this claim by BUAC, a public law body, was a civil and commercial matter. BUAC said that they had no power to make a binding determination. They could simply bring the matter before the court. And at 58, that interpretation is contested by BUAC, by the Austrian government, which maintains that in the context of proceedings for payment of wage supplements, the Austrian court is to carry out a full review of all the elements of the application. The court said at 59, over to page 28, that was for the National Court. At paragraph 60, consequently, the Austrian law places BUAC in a legal position which derogates from the rules of general law regulating the exercise of an action for payment by attributing a constitutive effect to the determination by it of the claim and by excluding, according to the referring court, the possibility for the court hearing such an action to control the validity of the information on which that determination is based. Must be concluded that that body acted under a public law prerogative of its own, conferred by law. In other words, BUAC was making a binding determination. At 61, to the extent that this is the case in the dispute in the main proceedings, which it is for the referring court to determine, the role played by BUAC cannot be characterised as that of a simple collective body governed by public law, tasked with collecting the resources for the payment of claims covered by the BUAC. In such a case, BUAC should be considered to be acting in the exercise of state authority in the context of disputes such as that which led to the judgment, which would have a major influence over the modalities for the exercise of that procedure and therefore over its very nature, such that that dispute does not come within the concept of civil and commercial matters. In other words, because BUAC was able to determine the matter, this was not a civil and commercial claim. It was a public law issue. But on the issue which we are concerned with, 63 and 64, as regards BUAC's powers of investigation, in the event that the employer breaches its obligation to provide information, it should be noted that those powers are also not in themselves such as to confer a public law character on a procedure such as that which led to the judgment. The prerogatives referred to in the previous paragraphs have no influence over the capacity in which BUAC acts in the context of a procedure such as that in the main proceedings, and do not modify the nature or determine the evolution thereof. So we say what this means is that the court focuses on whether the proceedings which are being brought are normal civil proceedings, in the sense that the claimant, here BUAC, must prove its case with no special status given to its role or indeed its evidence. It has to prove its case. And BUAC failed because its determination was determinative, subject to legal questions.
So the analogy would be with the tax authority which issues an assessment.
Yes, precisely so.
But the fact that they may have a power to enforce interview techniques or acquisition of evidence. The analogy here suggests that's probably not enough.
It's not enough in my submission. It's not enough if the nature of the proceedings are normal proceedings in the sense that the claimant has to prove its case.
So if it puts the public authority in a special or privileged position, then the exception may apply.
Yes, if in the proceedings the authority is in a specially privileged position, either because its determination is binding, subject to some legal argument, or its evidence has a special force or effect, then you're not within the scope of civil and commercial. That's what this court is saying consistently with Movich, which comes later. But I mean, Movich is to like effect, albeit clearer than Buac. So we say, in the present case, there can be no dispute that these are ordinary civil proceedings in the sense we have to prove our case, we have to adduce our evidence, the respondents are entitled to adduce what evidence they like, and our belief that they are fraudsters doesn't take us any further forward, and our evidence is treated in the same way as any other evidence before the court. And that was the conclusion reached by the judge.
I mean, it's difficult to think of a precise analogy, but if you had, I mean, my lord's given the example of assessment, if you had a claim by a public body which had carried out an investigation and that somehow had some sort of prima facie evidential
Yes.
effect,
Well, one does sometimes
then
see
that might
Yes. Yeah. I mean, it's a context far away from this, but one does sometimes see in the realm of public law statutory provisions that provide that the position taken by a particular person, whether it's the Attorney General, shall not be challenged on a particular matter. But we're a long way away from that in the circumstances of this case. We have to prove our case in the normal way. And that's what the judge said. The judge said, it's paragraph 174 of his lordship's judgment below. He said at 174, in the present litigation, I agree with the defendants that it is, as they put it, blindingly obvious that SCAT made use and may well have continued to make use of powers it has as a sovereign tax authority that no private litigant would have to investigate, to obtain evidence that it could use if it wished in the litigation, and has to a material extent already used in the litigation. On the authority of Buac and Movich, however, and I've just shown the lordships those authorities, that is beside the point. SCAT was neither attempting nor able to change the rules of the litigation game, either as to the substantive rules of law that would apply in determining its claims, or as regards the procedural rules applicable in the litigation, or as regards the status or effect of any of the evidence it might deploy or disclose. SCAT was not by this litigation pursuing public law proceedings in which liabilities are determined as if this were a judicial review of SCAT's actions, decisions, or exercise of public powers, rather than upon the same legal basis, substantive and procedural, as claims of this kind it seeks to pursue, e.g. for damages for deceit or for negligence brought by a private law entity. And we say that is that's correct with respect, and it's founded on the cases that the judge, to which the judge refers, Buac and most significantly Movich. At the very least, the judge was entitled, without there being any error of law, to come to that conclusion. That's sufficient for my purposes, but I just mentioned that we could go a stage further because we addressed in some detail in our re-amended reply to the defence of Mr. Knott and Mr. Hugerworth, who've taken this point, the information we'd actually obtained. And can I very briefly just ask the court to look at Supplementary Bundle 1, SB1, tab number 15, SB1 stroke 15 re-amended reply to the defence of Mr. Knott and Mr. Hoogerworth, and this responds to the complaints that we'd obtained and used evidence which we'd obtained by the use of our public powers. And there's a lot of detail here, but first of all, starting at page 6, in the middle of the page, there's a response to particulars of SCAT's alleged use of public powers, and we deal with the alleged general use of public powers and use of material from criminal investigations. And there's some detail set out on page 8 and then on page 9, where we explain that all of this material was available to private persons if they wish to see it. At page 8, page 9, I'm not going to read it all out, but I just give your lordships the references, and pages 10 and 11. And similarly, page 13, paragraph 16.3. Then we deal with information that had been obtained from other authorities abroad, and we explain at, and again I'm not going to read all this out, but at page 24, paragraph 32.2, we explain why we'd sought information. 32.3, to assist us in coming to an informed view as to whether we were wrong to accept the refund applications. We say in relation to Germany, 32.4, they'd provided no substantive information. We've not used any of this material. It's been disclosed, 32.6, and produced to the defendants who are in the same or material similar position as SCAT. And the same is true of the US on page 25, again without reading it all out, and other authorities. So if it matters, and I say it doesn't matter, but if it were to matter, the pleaded position is that all the information that we have obtained has been disclosed to the respondents, and in any event they would have been entitled under Danish law to seek that information and to obtain it. So I make that point, but it's not the relevant point on our submissions, because the relevant question is not what we have obtained and how, but whether what we are using in these proceedings has a special status or authority, and it doesn't. The respondents rely on what happened in Sunico when it was sent back to the Danish High Court. Your Lordship may have noticed they make a point about that. The judge dealt with this at paragraph 145 of his judgment, where his Lordship made the point that the Danish court misunderstood the relevant EU law criteria, understandably so, because they looked at the matter prior to the clarification of the issue by the Court of Justice in Movic and in Buak. Buak was 2019, Movic was early in 2020. There's one other case, one other line of authority that we rely upon in relation to the Article 1 criteria. I showed your Lordships this morning the authority in the United States that it is not an exercise of sovereign authority to seek to recoup monies paid pursuant to a statutory scheme if that money had been paid by mistake or under a misunderstanding or because of a misrepresentation. There's a similar line of authority in the Court of Justice. And the case that I draw attention to is in the supplementary appellants authorities, SAA 2 at tab 12, case of Land, Berlin and Sakia. SAA 2, tab number 12, Land, Berlin and Sakia. And it's a very similar case to the New York case. If your lordships would go to page 26 of the electronic volume, we see at paragraph 2 on page 26 the context that the request for a preliminary ruling has been made in proceedings between, on the one hand, Land Berlin, and on the other, certain individuals concerning the repayment of an amount overpaid in error following an administrative procedure designed to provide compensation in respect of the loss of real property during persecution during the Nazi regime. And the facts are set out in more detail starting on page 28 at paragraph 17 and through to page 29 on paragraph 22 and 23. What had happened was that the Federal Republic had made payments to the successors in title of those whose land had been misappropriated or expropriated under the Nazi regime. There were overpayments. That was the allegation, overpayments. And the question sent by the German court to the Court of Justice is on page 30 at paragraph 28. The question sent to the court in Luxembourg, page 30, paragraph 28(1), does a claim for the repayment of an amount unduly paid constitute a civil matter within the meaning of Article 1.1, where a land, the local authority, ordered by a public authority to pay to victims by way of compensation part of the proceeds from a sale of land, instead erroneously pays to those parties the entire purchase price. And over the page, page 31, paragraph 33, your lordships see the now familiar rubric that certain actions, paragraph 33, certain actions between a public authority and a person governed by private law may come within the scope of Regulation 44/2001. It is otherwise where the public authority is acting in the exercise of its public powers. 34, in order to determine whether that is the case, it's necessary to examine the basis and the detailed rules governing the bringing of the action. 35, they emphasise that the right to compensation which gives rise to the action concerning compensation for victims of Nazi regime were identical for all owners of property subject to restitutionary rights, the same obligation to pay compensation without distinguishing between the status of the owner of the property subject to such rights or a state entity. 36, it's clear the administrative procedure is identical whatever the status of the owner concerned. The owner does not have any prior right to a decision. 37, it must be observed the action in the main proceedings concerns recovery of an overpayment erroneously made when the public body gave effect to the victim's payment rights. The restitution of that overpayment is not part of the administrative procedure laid down by the legislation. And secondly, for the purposes of the recovery of that overpayment, the owner, whether public or private, must bring an action against the victims before the civil courts. Likewise, the legal basis for that recovery consists of the rules laid down in the civil code concerning restitution based on unjust enrichment. In the light of the following, of all the foregoing, the answer is that Article 1.1 must be interpreted as meaning that the concept of civil and commercial matters includes an action for recovery of an amount unduly paid in the case where a public body is required by an authority established by a law providing compensation in respect of acts of persecution to pay to a victim by way of compensation part of the proceeds of the sale, and it has, as a result of an unintentional error, paid to that person the entire sale price, and it subsequently brings legal proceedings seeking to recover the amount unduly paid. So we rely on that as well, recognising that a claim for an overpayment is not an exercise of public powers. It's a claim, as in any civil claim, to recover that which the other party was not entitled to receive. We say a fortiori if the receiving party is the author of the error by reason of its fraud or misrepresentation, which is not, I don't think, a part of the reasoning of the court in this case. I notice it's 3 o'clock. This may be a suitable moment for the 5-minute break.
How are you getting on?
I'm hoping either to finish this afternoon or very early tomorrow morning, probably very early tomorrow morning, but I'm certainly within the time allocated for our part of the case, allowing, of course, for Mr. Feely to have his opportunity to address your lordships as well.
Good. Well, 5 minutes.
Court rise.
Stuff I left in there from my school.
Yeah, I think
I did a hearing in July in the main ICJ, and it was
I've got to, so I can leave that out, and I can just. It is a little bit, yeah.
turn it down a bit.
Yeah. I think, yeah, a bit of fresh air would be useful for all sorts of reasons. I think I'll just go to Franz.
Yeah, well, actually, I didn't do it because Flo gave a speech with dignity of court. Exactly, there's only like four. I've just turned
I didn't get You overheard me saying about my experience in July.
It was timely because I was subconsciously thinking about it. I've turned it down from, when I got in here this morning, down to 3, so it was a 5.5.
I actually, I think it's probably worse for us than for you guys, but we're all jamming together here and we've got, fully happy.
Very true. You weren't in court last year over the RCJ when the aircon.
Yeah, that was the one. Yeah, July. I was doing with Justice Lewis.
Should have just been that's it. Because really, if that was in Australia, I think that would have done that.
Yeah, I can't remember who Lord Justice Lewis was sitting with, but when on day 2 I stood up in my turn to speak and just said, I'm very sorry, I've disrobed already. There's no way.
We were fortunate enough, the judge said, right, no, he's nothing. Just take your sleep coat off.
Are you the associate with the Chancellor?
No.
Very.
If
based over here?
No, I like it over here. I don't claim. So if there's a Court of Appeal, the Chancellor's presiding, then you come over.
This is the Chancellor's Court.
It is.
Oh, is it? I thought it was a bigger one. I thought it was a bigger one that's huge. Sort of twice the size.
I can't really comment. I know this is definitely his call.
That's when I was called as some years ago, 2012, the configuration of the court. We did about and there is a mega court. It's one.
Yeah, I'm not sure which one that is.
Like some help explain. I should do with it. Okay.
Was he just very...
No, let's go first.
Court rise.
My lords, one final matter on whether this is a civil and commercial matter for the purposes of Article 1. I need to take your lordships to the judgment of Lord Justice Simon Brown for this court in the Franzen case, on which my friends rely. The court will find it in Principal Authorities Volume 1, PA1 at tab number 10. My friends rely on this case as to why they say it's not a civil and commercial matter. We rely on this case, as I shall indicate in a moment, as to why, if it is a civil and commercial matter, Dicey Rule 3 cannot be applied. So we are both seeking to rely on Lord Justice Simon Brown and the other members of the court. The context here, as lordships may recall, is that the plaintiffs were Danish companies. The Danish tax authorities were claiming against them substantial sums in respect of corporation tax. The plaintiffs had no assets, and so the Danish tax authorities appointed a liquidator. They funded an action here in England by the plaintiffs against the defendant, who was the former owner of the companies, who disposed of all the assets. And the liquidator wanted restitution of the value of the assets or damages for negligence. And the first question, was whether this was a revenue matter, and so excluded from the Brussels Convention under Article 1.1. And the Court of Appeal accepted that it was not a civil and commercial matter, and it did so at page 2174. It's page 6 of the report, electronic version. And if I pick it up at letter E, Lord Justice Simon Brown, speaking for the court, says there's no definition of revenue matter in the Convention, no decision of the European Court of Justice bearing on the point. This is, of course, in 1999.
So I'm sorry, Lord Pike, I'm not sure I'm in the right place.
I'm sorry, Lord.
Page,
Page 6 of the electronic
yeah,
bundle,
sorry, yeah, I'm looking.
and I'm looking at E.
Yes,
There's no definition, says His Lordship, of revenue matters in the
Yes.
Convention. That's still true. No decision of the ECJ bearing on the point. No longer true. At C, Sunico and Sakia. At F, I understand the plaintiffs to accept that direct revenue claims would fall within the exception. What they argue is that indirect claims are not excluded, and certainly not a claim like the present. This, they submit, is a private law claim, not merely in form but in substance. The difficulty with the argument is that it necessarily implies that Buchanan was wrongly decided and that the courts of other member states, unlike the House of Lords, would so regard it. Nothing that we've been shown in the foreign jurisprudence or commentaries supports such a view. Perhaps understandable at the time, but overtaken in our submission by Sunico, as the judge below said, and indeed Sakia in 2013. And that was what the judge below decided. He correctly decided in our submission, paragraph 149, that this part of Franson is simply inconsistent and must give way to the principles stated by the Court of Justice in the Sunico judgment as to what is a civil and commercial matter in a tax context. Those are our submissions on the first part of ground 2 as to why we say this is a civil and commercial matter. If we are correct, if the judge was correct on that, then the final question under ground 2 is whether the English court can, consistently with the regulation, decline to exercise its jurisdiction by reference to Dicey Rule 3.1. And the reasoning of His Lordship below, particularly at paragraph 147, is that Dicey Rule 3.1 is a substantive rule of law, rule of public policy. It's not a rule of jurisdiction, which is the subject matter, jurisdiction that is the subject matter of the Brussels regulation, the Recast Regulation. And therefore, says the judge, Dicey 3.1 and its applicability is unaffected by the Recast Regulation. Now, our submission, in essence, is that the relevant question is not how best to characterise Dicey Rule 3.1 as a matter of English law. The relevant question is one of EU law. And the question, we say, is whether the application of Dicey Rule 3.1 would have the effect of derogating from the Brussels regulation or otherwise impairing the effectiveness of the Brussels regulation. And we say that to apply Dicey Rule 3.1 to a case which is otherwise within the scope of Article 1 of the regulation would substantially impair the application of the jurisdictional rules laid down in this regulation. It would mean, and indeed this is what the respondents want it to mean, it would mean that the English court does not rule on the merits of the substantive claim, that the court would choose not to exercise, as Lord Gough put it, its jurisdiction. And that would deny the benefit of the provisions of the regulation to bring proceedings in the courts of the defendant's domicile. And we therefore submit that to apply regulation, Rule 3.1, in substance derogates from the regulation, and impermissibly so. All the more so when we say one of the purposes of Article 1 of the regulation, one of the purposes when it identifies whether a claim is civil and commercial, is to exclude those claims which, as a matter of EU law, are considered to be exercises of public power. And your lordships have seen the principle laying that down, but there are more obvious cases that we wish to draw attention to that demonstrate the principles that the EU is applying in this respect. Can I just show your lordships the Lechoritu case, which is in the supplementary Respondents bundle of authorities, number 5. That is SRA 5, tab number 50. And your lordships will see from the beginning of the head note the context here. The claimants had issued proceedings in Greece seeking compensation from Germany in respect of financial loss, non-material damage and mental anguish caused to them by acts perpetrated by German armed forces against their parents during the Second World War. And the Court of Justice held that this did not fall within the scope of Article 1 of the regulation because it was a claim based on the exercise of sovereign authority. Paragraph 31 of the judgment is at page 23, electronic page 23. And it sets out the basic principle that your lordships are very familiar with. Paragraph 31, in the middle of page 23. Thus, the court has held that although certain actions between a public authority and a person governed by private law may come within the scope of the Brussels Convention, it is otherwise where the public authority is acting in the exercise of its public powers. And then at 36, further down the page, the legal action for compensation brought by the plaintiffs in the main proceedings against the Federal Republic derives from operations conducted by armed forces during the Second World War. 37. As the Advocate General has observed, there is no doubt that operations conducted by armed forces are one of the characteristic emanations of state sovereignty. In particular, inasmuch as, over the page, they are decided upon in a unilateral and binding manner by the competent public authorities and appear as inextricably linked to states' foreign and defence policy. It follows that acts such as those which are at the origin of the loss and damage pleaded by the plaintiffs in the main proceedings, therefore if the action for damages brought by them before the court, must be regarded as resulting from the exercise of public powers on the part of the state concerned on the date when those acts were performed. And then we see the operative provision at page 25. I'm sorry, I apologise. I should also read paragraph 39, the next paragraph on page 24. Having regard to the case law recalled at paragraph 30, a legal action such as that brought before the referring court therefore does not fall within the scope ratione materiae of the Brussels Convention as defined in the first sentence of the first paragraph of Article 1 thereof. In other words, it's not a civil and commercial matter. My point is that Article 1 of the Convention therefore itself distinguishes between what it regards as civil and commercial matters and what it by contrast regards as exercises of public powers, in particular in the area of state sovereignty. And my submission is that if applying the principles of Article 1 of the regulation and all the case law, we are right that this case is not a case of the exercise of public powers, but it is a civil or commercial claim, it cannot, we respectfully submit, be open to the English court, or indeed any other national court, to apply its own rules as to claims of a sovereign nature in order to refuse to hear the substance of the claim. And the reason for that is that the national court would frustrate one of the purposes and effects of Article 1 by imposing national criteria in substitution for the criteria which the Court of Justice applies under Article 1. For the English court to say that because we categorise this claim as one of sovereign authority, even though the Court of Justice does not under Article 1, therefore the claim may not be brought in the courts of the defendant's domicile, would be to substitute a national rule for the rules of EU law which expressly address the same issue. The regulation, I say, cannot allow each member state, each state, to apply its own principles as to what is a claim based on sovereign authority or the use of public powers. Either the criteria are the same, in which case Dicey Rule 3.1 adds nothing. That was the point that my Lord put to me at the beginning of this afternoon. Or Dicey Rule 3.1 applies different criteria, in which case its application would conflict with and therefore undermine the EU law criteria. So I'm seeking to make 2 points. My first point is that to say you won't hear a case is a decision which undermines the grant of jurisdiction by Article 1 of the regulation. To say we have jurisdiction, but we're not going to exercise it, is to frustrate the conferral of jurisdiction on you.
And that isn't always the case, is it? Because, for example, we substantively refuse to entertain actions for various public policy grounds, including illegality, even though there would be jurisdiction. So it isn't right to say that by refusing to entertain a claim, you are thwarting jurisdiction.
No, I accept that, and that's
The
why...
distinction between that sort of case and the other example that's given is limitation. Is, I think you say, well, the distinction is that this is an area where the regulation and EU law expressly deals with the very threshold issue, if you like, if you can describe it in that way.
Yes.
As to whether or not there's jurisdiction. Yes. And if you start substituting another English law rule, even if it's a rule that's based on international law, which is one of the
Well, I'm coming to that, yes.
I thought you might be, then you are potentially substituting a different rule for the rules under the regulation. Of course, the other way of looking at it is the one that I put to you at the beginning, which is that they're intended to be one and the same. And if you're right about ground one, then none of this matters.
Indeed. There are two answers I would seek to give to my Lord Justice Phillips' point. The first is that my Lord the Chancellor has summarised that here the rule of national law upon which the respondents rely is a rule which addresses the substance of the very issue which is addressed by Article 1 of the regulation. And I've made my submissions on that. I've shown you, Lordship, the cases. Lecherito is a very stark example that Article 1 is addressing the sort of arguments. It's not done in exactly the same way. It's the same concern. There are claims which it is inappropriate for the court to hear and determine because they are, in substance, claims that are based on the exercise of sovereign powers, public powers. And I've made the point, I say you can't substitute for whatever is the answer under the regulation, the answer that you get under a distinct national rule. That's the first answer I give. But I have a second answer, respectfully, to my Lord's point, that there is a distinction between the court forming a view as to whether it should hear the substance of a claim for reasons such as illegality and the application of a rule that is enshrined in Dicey Rule 3.1. And the reason why it is different is because the basis of Dicey Rule 3.1 is that given by Lord Gough in the passage that my Lord the Chancellor referred to at the outset of these proceedings, and I took the court to, where Lord Gough said, what the English court does is simply to decline in such cases to exercise its jurisdiction. So it's not that the court doesn't have jurisdiction, the court is taking a specific decision. It's saying we will not exercise a jurisdiction. And my point, by way of seeking to distinguish other possible cases, is that the English court cannot rely on a rule which allows it to decline to exercise jurisdiction, when the whole point of the regulation is to confer jurisdiction. It is to derogate from a jurisdictional rule by reference to jurisdictional factors. It is...
That is where I cease to follow you, because we're talking about jurisdiction in the sense of jurisdiction as between jurisdictions. Does the English court have jurisdiction? And whether or not the English court decides to exercise its jurisdiction in a broader sense, that the English court has jurisdiction to make various orders, give various relief. You have jurisdiction to deal with the case. You decline to exercise any jurisdiction to deal with the matter substantively.
At all.
I don't see, well, what would you do with the case? You would dismiss it.
Well, indeed, but my concern is that the English court is saying we have jurisdiction, but because of the nature of the claim, we will not entertain it at all.
Yes,
Also true of illegality.
yes. Any public policy issue, the court says, as a matter of policy, we won't entertain the claim.
Yes.
It's semantics to some extent.
I mean, I follow your first point about derogation
Yes,
from the regulation. I think you're on stronger ground there. I think on this second point, I think that
No, well, I understand
There is an issue.
the court's concerned about, particularly about the second point. Just in relation to that, can I show the court what was said by Lord Justice Simon Brown in Franzen?
Yeah.
Because he did address this issue. It's in the Principal Authorities, Volume 1, and it's at tab number 10, Principal Authorities, Volume 1, tab 10. And his lordship dealt with this part of the case starting at, well, it's page 3 of the electronic bundle, 2171 of the report. At the bottom of the page, just under G, he says, do the authorities on indirect enforcement survive the UK's accession to the treaty and implementation of the Convention on Jurisdiction and Enforcement? So that's the issue in the appeal. At 2177, which is page 9, between F and G, well, starting at D, the issue 2 was whether the claim could be struck out even if the convention applies, in other words, even if Article 1 applies. And at F, his lordship says, before examining the conclusion, I should note that although Rule 3 is framed as a rule that English courts have no jurisdiction to entertain actions of the kind in question, both sides accept Lord Goff's dictum in Norway that the rule does not affect the jurisdiction of the court, but is concerned rather with circumstances in which the court declines to exercise its jurisdiction. So his lordship understood that basic point. And then over the page, page 10, my lords, at letter C, his lordship says, assuming, and he found it wasn't the case, but assuming that the present claim is a civil matter within Article 1, and therefore that under Article 2 there is jurisdiction to bring it in England against the defendant as someone domiciled here, the plaintiffs submit that Rule 3 cannot properly be invoked so that the court immediately then declines to exercise its jurisdiction. Such an application of Rule 3 would clearly impair the effectiveness of the convention. Mr. Ivory, for the defendant, submits the contrary. He argues that Rule 3 is not concerned with the appropriate place for the trial of the action. There is, he submits, no difference between striking out the claim under Rule 3 and striking it out because of some other ground it is bound to fail. For example, for lack of merit or under the Limitation Act. On this issue, says the judge, it seems to me that the plaintiff's argument is plainly right. The necessary corollary of Rule 3 of Dicey and Morris is that any such claim as this can only properly be brought in the tax authority's own courts. Were the convention to apply, Rule 3, in other words, were Article 1 to apply, Rule 3 would seem to his lordship not merely to impair its effectiveness, but indeed substantially to derogate from it. So his lordship is proceeding on the basis that Dicey Rule 3, albeit it is not a rule that denies jurisdiction to the English court, is nevertheless a rule that ascribes to another state the function of providing the jurisdiction in which the claim, because it's a revenue claim, should be heard. And that's, we say, the vice of applying Dicey Rule 3 in the context of the convention, and why it's different from a limitation argument or some of the other examples that have been given. The court is saying, the domestic court is saying, don't bring it here because it's a claim by a sovereign authority exercising sovereign powers, and therefore, as a matter of English law, the only proper place it can be brought is in the courts of the Kingdom of Denmark.
My understanding, though, is, and you took us through it very carefully, is that the approach to whether or not something is a civil matter within Article 1 is addressed at these proceedings, not the overall relationship. And I think you took us to a number of statements of authority. Whereas Dicey Rule 3 is looking at something different, which is the substantive underlying relationship. So we are looking at two different things. And
I entirely accept that. I'm not submitting, I make it clear, that the tests are the same under Dicey Rule 3 and under Regulation 1. My submission is that both of those legal instruments are attempting in their own way to address the same general problem, which is whether or not this is a claim which, by reason of the public powers and the sovereign nature of the claim, is one that the courts should not entertain.
But then you're watering down a well-established rule of substantive law on the basis of a jurisdictional gateway. And why should we entertain overturning law established by the highest courts of this country because of a jurisdictional regime which doesn't deal with substantive law at all?
But which authority is your lordship suggesting I'm inviting the court to overturn?
Well,
there is no authority, I think, on this question apart from Franzen, which I accept is not binding because it's an obiter statement.
Well, you accept that the jurisdictional test is different from the rule of substantive law.
Yes.
So if you're asking us to say that we don't apply Dicey 3, then you are
I understand.
effectively saying that a rule of substantive English law has been superseded
Yes,
or
yes.
preceded, but now superseded by a procedural rule.
I'm having a more fundamental difficulty with this.
May I answer that one before
Yeah,
I deal?
do. I think it's a very good
Before I attempt to deal with the more fundamental
I'm
problem.
not sure it gets
Yes,
more
I take your lordship, well, only because otherwise I'll forget the
Fortunately, I've written my question down, so I won't forget.
answer. I would suggest to your lordship that what your lordship says is undoubtedly correct. My argument,
It's a good starting point. Bob.
yes, entirely correct. But it is trite law that if the regulation so requires, then rules of national law must be displaced. Indeed, the withdrawal agreement specifically so requires. And the question therefore remains whether there is or is not substance in the submissions that I make to this court as to why it would derogate.
But Dicey 3 has been applied well after the regulation has come into force.
It has.
So
I'm not aware that anyone has raised this issue or that any court has pronounced upon it other, as I say, than Franzen.
So this is a really good time to be taking the point.
We are where we are, and this case is raised for determination. Now, I'm not seeking to be flippant. I mean, this is an important question of law, and it raises the question of the scope of the regulation. As I've said, I do rely on what Lord Justice Simon Brown says, that the essence of Dicey Rule 3.1 is an attribution to another state of the responsibility, sole responsibility under Dicey Rule 3.1 for determining issues that are properly categorised as not civil and commercial in English law or revenue or public policy matters. And I secondly say, by reference to all the authorities that I've cited, that the case law under the regulation is attempting to draw a line, just as Dicey does, Dicey Rule 3.1, between claims that it is appropriate for the court to determine and those that are not. But I recognise it's the two are not the same. If they were the same, we wouldn't be having this argument. So that's the best I can do in answer to my lord on this point.
Hold up, my lord, for one more moment. Just to be clear, Lord Justice Simon Brown's dictum, whilst persuasive, was obiter
Yes.
and also in circumstances where you contended that his primary finding has now been superseded anyway. So that's really walking on water as well.
No, I'm not suggesting that this is in any way binding. I accept the court had determined that this was not a civil and commercial matter, and therefore this is not a part of the essential reasoning. But I draw attention to it because it is, so far as I'm aware, the only authority on the precise question with which the court is being asked to determine. But I don't suggest it's binding. I commend the reasoning to this court, but the court will make up its own mind. I'm sorry, my lord has been very patient. I need to listen to the more fundamental problem the lordship has.
Well, I'm not quite put off, Mr. Panic. No, Panic. What troubles me is how real it is to say that you can actually have a case which falls within Dicey Rule 3 because it is a sovereign enforcement of its tax legislation. And yet when one comes to look at Brussels, it's civil and commercial. Because I'm very sorry to say, I just don't get it. It seems to me to
There
be
may be different. I think I have the same problem. I mean, you're absolutely right that they are different tests, but there's not that much difference between them. And that's. I mean, it may come back to the fact that on one or other point, the judge's conclusion is wrong.
Yes.
Because if you're right on ground one, then this doesn't really arise.
Well, that's the point, really.
And if he was right on ground one, then why on earth isn't it a revenue matter?
Well, the answer to that is that Sunico applies a particularly tough test before it is a revenue matter. But the main answer, I understand your lordship's point, the main answer, of course, is that the submissions I'm now making are obiter submissions in the sense that my primary position is that Dicey Rule 3.1 does not apply in the circumstances of this case. And if I'm right on that, then Dicey Rule 3.1 poses no difficulty.
If we're with you on that, then if we were to say anything on the point you've just been addressing, that too would be obiter.
I respectfully agree with your lordships. I should mention, for the sake of completeness, that we would still need to succeed in relation to ground 2, both because that is the only ground on which we are pursuing ED and F-man, and because there are, I think, a very limited number, one other respondent who is not pursued under ground 1 because the jurisdictional criteria are not satisfied in relation to them. But it would simply, if we're right on ground 1, then the only issue under ground 2 is this a civil and commercial matter and not a revenue matter for the purposes of EU law, and that would be the end of it if we're right on that. I take your lordship's point. So these submissions they're made in the context that we don't accept, for all the reasons I identified, that Dicey Rule 3.1 is a problem in any event for us. There's a great deal of authority in relation to this question of what is covered by jurisdictional rules. Your lordships, I anticipate, are very familiar with Owusu and forum non-conveniens rules cannot be applied because they would derogate from the scope of the convention. Just for your lordships note, it's the Principal Authorities, Volume 8, tab 71. I ought also just to address other points that have been raised here. Yes, I mean this general issue has been looked at in a number of authorities. Can I show the court Authorities Volume 2, tab 16, which is the Viking case. Volume 2, tab 16, Viking Line and International Transport Workers Federation. It's a judgment of Mrs. Justice Gloucester, as she then was, and the defendants were arguing that the commercial court should not grant an injunction to restrain industrial action in Finland because it was said the court and the court was said to have jurisdiction over the defendants under the Brussels regulation. The relevant passage is at paragraph 71, which is on page 33. And your lordships will see, well, starting at paragraph 70, what was being argued was that a principle of comity or analogous principles should be applied to make it inappropriate for the court of this jurisdiction to entertain the claim. And at paragraph 70, Her Ladyship said in the middle, where jurisdiction is founded on the Brussels regulation or in its predecessor, the Convention, the court has no power to decline to exercise that jurisdiction on the ground it would be more suitable for the dispute between the parties to be litigated before the courts of another state. And at the bottom of the page, paragraph 71, in the fourth line, where a court has jurisdiction under the regulation, it cannot refuse to exercise it on the ground that the courts of another contracting state, or indeed of a non-contracting state, would be a more suitable forum for resolution of the dispute. Common law notion of forum non conveniens over the page, page 34, has no place in the regulation. I accept Mr. Hollander's submission. The defendants are wrong to attempt to draw a distinction between jurisdiction and comity as if they were entirely separate issues. They're intimately bound up together. If I were to accede to the defendant's submissions on comity, this court would in effect be declining to exercise the jurisdiction accorded to it by the Brussels regulation. And this court agreed with Mrs. Justice Gloucester at the next tab, tab 17, PA 217, page 4, paragraph 2. So I draw that to the attention of the court. I should also mention that the Supreme Court, on a very analogous issue, thought the issue was one that they wouldn't decide. It's the Lucasfilm case, your lordships may wish to be reminded of. It's in the Principal Authorities Bundle, volume 4, at tab 27, and the relevant issue arises at the end of the judgment, the joint judgment of Lord Walker and Lord Collins speaking for the Supreme Court. So it's PA 4/27, page 37 of the electronic bundle. This was in the context of a trademark dispute. Paragraph 112, Lucasfilm argues that it would be inconsistent with the Owusu principle, that's the principle the court cannot decide not to hear the case because of forum non conveniens, for the English court to decline to decide a particular issue on the ground that it is not justiciable under English law, because in particular the Brussels I regulation is concerned with subject matter jurisdiction as well as personal jurisdiction. It's concerned with achieving the uniform application of common principles regarding jurisdiction across the European community, and it would not be consistent with that object if national courts were able to decline jurisdiction on principles of non-justiciability. Although in argument it was stressed that the argument was one of lack of jurisdiction rather than non-justiciability, in substance the real point of the argument is that if Lucasfilm were right, then the Brussels I regulation would require the English court to adjudicate on other matters which have hitherto been regarded as non-justiciable, such as the transactions of foreign sovereign states, which were held to be non-justiciable in Boots Gas, and that to require the English courts so to adjudicate would be contrary to international law, or perhaps more accurately put the UK in breach of international law. In view of the conclusion on the main point, this issue, on which a reference to the European Court might be required, sadly or happily no longer available, does not arise, and there is no need to express a view on it. So I would add to my response to my Lord Justice Phillips, it isn't the case that it has been acknowledged, accepted, recognised that the Brussels regulation and its jurisdictional rules may require reconsideration of non-justiciability, to use a general term, issues. On the contrary, Lord Collins and Lord Walker, speaking for the Supreme Court, recognised at the very least that this was a difficult question of law, to which the answer was not, at the very least, plain and obvious. I can't take that further, but it is a recognition of the complexity and indeed the importance, it may be, of the issue that this point raises if we are wrong on Dicey Rule 3.1. So I draw attention to that statement. I also should mention the judgment of the Court of Justice which my friends rely upon, the Cheville case, which is Principal Authorities Volume 8 at tab number 65. This is a judgment of the Grand Chamber of the Court of Justice, and the context in which the court was giving its view appears, Principal Authorities, Volume 8, tab 65. If we could please go to page 46, electronic page 46. And at paragraph 34, the court says that the national court's various questions essentially ask whether, in determining whether it has jurisdiction court of the place where the damage occurred pursuant to the convention as interpreted by the court, it is required to follow specific rules different from those laid down by its national law in relation to the criteria for assessing whether the event in question is harmful, and in relation to the evidence required of the existence and extent of the harm alleged by the victim of the defamation. And then 35, which my friends rely upon, in order to reply to those questions, it must first be noted that the object of the convention, it's the Brussels Convention, is not to unify the rules of substantive law and of procedure of the different contracting states, but to determine which court has jurisdiction in disputes relating to civil and commercial matters in relations between the contracting states, and to facilitate the enforcement of judgments. My friends rely on that, and the court will understand why. 36, moreover, the court has consistently held that as regards procedural rules, reference must be made to the national rules applicable by the national court, provided that the application of those rules does not impair the effectiveness of the convention. And then at 37 they deal with non-contractual liability. At 38 they say the convention does not specify the circumstances in which the event giving rise to the harm may be considered to be harmful to the victim, or the evidence which the plaintiff must adduce. 39, those questions must therefore be settled solely by the national court seized, applying the substantive law determined by its national conflict of laws rules, provided that the effectiveness of the convention is not thereby impaired. And we rely on that. And we say, for the reasons that I've sought to identify, that to apply Dicey Rule 3.1 would impair the effectiveness of the convention, both because the convention draws a line of its own between cases that are exercises of public powers and cases that are not, but also because Dicey Rule 3.1 purports to say which court, that is the court of the tax authority, is the only one which can and should hear the claim as a matter of English law. We also point out that the regulation contains no public policy exception to the rules on jurisdiction, and that's by way of contrast to the way in which the regulation addresses recognition and enforcement of judgments, Article 45.1 and 46. The judge below took the view that the regulation allows for the application of Dicey Rule 3.1 because he said the latter is an overriding mandatory provision under Article 16 of the Rome II regulation. That is, well, it's in Authorities 10, perhaps we should go to that. Authorities, Principal Authorities, Volume 10, at tab 87. And I draw to the court's attention that on the first page of this regulation, the Rome II regulation, on the right-hand side, Preamble 7, the substantive scope and provisions of this regulation should be consistent with the Brussels regulation on jurisdiction and recognition and enforcement of judgments. And over the page, page 2, the court will see Article 16 set out, overriding mandatory provisions. Nothing in this regulation shall restrict the application of the provisions of the law of the forum in a situation where they are mandatory, irrespective of the law otherwise applicable to the non-contractual obligation. And his lordship said at paragraph 162 of the judgment that Dicey Rule 3.1 is in substance an overriding mandatory obligation. The difficulty with that argument is that the Court of Justice has held that the application of national rules, whatever their status, whatever their content, is impermissible in an area of law that has been fully harmonised by the EU. If we need authority, it's the PIPIG case, Authorities PA 8, tab 69. And perhaps we should look at that. Volume 8, tab 69 of the Principal Authorities, PA 869. And if the court, please, would look at page 32 of the electronic volume, the court will see the issue here, my lords, was arose under the directive on misleading advertising, and the question was whether national courts could apply stricter rules to prohibit comparative advertising than the directive laid down. And at page 32, paragraph 44, it follows the directive carried out an exhaustive harmonisation of the conditions under which comparative advertising in member states might be lawful. Such a harmonisation implies by its nature the lawfulness of comparative advertising throughout the community is to be assessed solely in the light of the criteria laid down by the community legislature. Stricter national provisions on protection against misleading advertising therefore cannot be applied to comparative advertising as regards the form and content of the comparison. So it's the same point. I say Article 1 of the regulation lays down the criteria and national law cannot depart from them. Then there's the international law issue. Your Lordships will have seen it's part of the Respondents' argument that Dicey Rule 3.1 is either a rule of customary international law or it's an emanation of a rule of customary international law, and as such it cannot be displaced by the Brussels regulation. To which our answer is, first of all, Dicey Rule 3.1 is a rule of domestic law. It's not a rule of international law, it's a rule of domestic law. And if it is to be categorised as a rule of customary international law, it needs to meet the criteria laid down by the Supreme Court in the General Dynamic case, which can be found in the Supplementary Appellants Authorities, Volume 1. SAA 1 at tab 8, Lords. General Dynamics against the State of Libya, and Lord Lloyd Jones for the court addressed the question of what needs to be proved for a rule of customary international law at page 22, Lords. And at paragraph 51 on page 22, his lordship says, in order to demonstrate the existence of a rule of customary law, it would be necessary for Libya to establish both widespread, representative and consistent state practice and an acceptance by states that the practice is followed as a matter of legal obligation, opinio juris. Now, we accept there may well be representative and consistent state practice based on an acceptance of legal obligation, that a state is not required to recognise in its territory the purported assertion of sovereign authority by another state. There's no dispute about that. But there is no representative and consistent state practice, far less acceptance of a legal obligation, as to the dividing line between an exercise of sovereign authority and a civil claim to recover sums paid out by the state by reason of fraud or misrepresentation. The absence of any such state practice is illustrated by the case law that the court has seen today. The US decision, for example, in the US Federal Court in New York, the Sunico decision, and we do not accept, nor can the respondents establish, that the particular way in which Dicey Rule 3.1 addresses this problem is a rule of customary international law, as opposed to the test that is applied by the EU in relation to jurisdiction. So there's no basis for saying that Dicey Rule 3.1, on my friend's approach to Dicey 3.1, is a statement of customary international law. And in any event, the UK has consented to the jurisdictional rules of the Brussels regulation. There's no question of breaching the UK's sovereignty by applying the regulation. So in our submission, customary international law does not take this case any further forward at all. There's no basis for suggesting that the content of customary international law is as it is defined in this case by the respondents, that is, to exclude a claim brought by SCAT in the circumstances of this case. One further point in relation to this difficult question of whether the convention precludes the application of Dicey Rule 3.1. We do say it would be anomalous for the court here to refuse to hear the merits of a case covered by Article 1 of the regulation, that is a civil and commercial claim, because of Dicey Rule 3.1, when the English court could not rely on Dicey Rule 3.1 to refuse to enforce a judgment obtained in another member state. And the correlation between those two circumstances is established by the Court of Justice in the Lugano opinion. The Lugano opinion can be found in Authorities Bundle 10 at tab 97. It's the full Court of Justice. And there's a paragraph at the end, it's page 63 of the electronic bundle. And the court says at 172, all the factors demonstrate that the community rules on the recognition and enforcement of judgments are indissociable from those on the jurisdiction of courts, with which they form a unified and coherent system. Now, recognition and enforcement is addressed under Chapter 3 of the Recast Regulation, which we have, the court will recall, at Principal Authorities PA 10 at 89. And Chapter 3 begins on page 14 of the electronic bundle tab, 89. And we say it would be anomalous for the English court to be able to refuse jurisdiction, or to refuse to exercise jurisdiction in a case within Article 1, although it is required to recognise and enforce a judgment from the courts of Denmark. The answer which the respondents give to this point is they say it would not be anomalous because the English court, if it's merely enforcing the Danish judgment, would not be put in the position of having to adjudicate on sovereign claims. That would be done in Denmark. And it's true that at the stage of enforcement of a judgment, the English court would not be making any assessment of the foreign law. But that's not the concern under Dicey Rule 3. The rule is concerned with enforcement, not with recognition. And a state seeking to enforce a foreign tax judgment of its courts in England is no less an extraterritorial enforcement of its sovereignty than seeking to have its tax claim adjudicated here.
But doesn't that depend on the doctrine of merger?
In what sense, Mark?
Well, a claim would merge into a judgment, and he wouldn't be enforcing the tax, he'd be enforcing the judgment.
Yes, you'd be enforcing the judgment in
So why does that offend Dicey 3?
Well, because under the regulation, there's no basis upon which you can refuse to recognise and enforce the judgment of a court in another contracting state, which has heard the matter and reached a determination. The whole point of of the regulation is to confer jurisdiction and then to require all states to recognise and enforce the judgment that has
I don't understand why it defends Dicey 3 then, because what Dicey 3 says is that this jurisdiction, we will not entertain a claim to enforce a foreign state's tax claims.
That's not the position if it's a foreign judgment. In Dicey Rule 3.1 doesn't say the English court will refuse to recognise.
If it's a judgment, if it's a judgment of a foreign court, there's an obligation. There's an obligation of the state in which enforcement is being sought to enforce a judgment that has been reached under the convention. There is a public policy exception, Article 45, which is on page 15. And Article 45, on the application of any interested party, the recognition of a judgment shall be refused if such recognition is manifestly contrary to public policy, ordre public, in the member state addressed. And Article 45.3, without prejudice to point E of paragraph 1, the jurisdiction of the court of origin may not be reviewed. The test of public policy referred to in point A may not be applied to the rules relating to jurisdiction. And there is case law on this public policy exception. It's the Diego Brands case, Authorities Volume.
Shall we go to that tomorrow morning? Because,
Yes.
I'm afraid this evening I really can't sit behind.
No, I understand. I've very nearly finished, but I'm very happy
I understand that, but I have to swear in somebody.
I understand. Your Lordship's been very
I
patient
need to
with
get
me today, so
into
thank you.
different roads, all of which takes time.
Thank you very much, my lords.
10:30 tomorrow morning.
Certainly.
Court rise.